Hello friends, my name is Vienteri. My NPN number is 1851118 and I am college student from University of International Batam. In this video, actually I will explain to you about definition of private international law. But because my English is not good, so I will ask my friend to help me to explain to you about the topic. And here she is, Cortana. Woo! Wait, Cortana? Wait, friends. Wait. I will search. Cortana? Cortana, where are you? Cortana.
I am here, and why you have to scream to find me?
Because you don't respond to me. So I think you go somewhere.
I am always in your mobile, stupid. Because I am application in your mobile.
I'm so sorry. I forgot about that.
Never mind. If you pay money to me, I will forget what happened today.
What? Why I must pay you money?
Because you scream me.
I scream to you to find you, not mad to you.
If you don't pay money to me, I never help you to finish this assignment.
Okay, I delete you now.
No problem to me. If you think your English is good, just do it.
Okay, never mind. I just need to pay you money and my assignment will finish.
Good.
Cortana, you are evil.
What you say?
Never mind.
You weird.
Okay, today Cortana will explain to you about what is definition of private international law or conflict of law. Yeah, maybe because I pay to her, so she will explain to you guys. And also I hope you guys enjoy what she explained, and I will stay here to listen to what she explanation. So now Cortana, you can start your explanation now.
Because him is not pay money to me, I will still give an explanation to you because I am a good application about definition of private international law or conflict of law. Before we discuss the definition of private international law or conflict of law, let us first discuss the history of the development of private international itself. The history of the development of private international law is divided into 5 stages, which will be explained as follows. A first stage, Roman Empire of the 6th century AD. This period is the beginning of the development of private international law. The reality is that it appears to be the relationship between the Roman citizens and the residents of the province or municipality, and the residents of the province or foreigners with each other within the territory of the Roman Empire. In the legal relationship, of course it has a dispute, and to settle the dispute a special court is formed called the Creator of Peregrines. The law used was ius civil, a law that applied to Roman citizens, which had been adapted for the benefit of outsiders. The private international law principle developed at this time and became an important principle in modern international civil law, namely 1. Lex areicity principle, lex site, which means matters involving immovable objects are subject to the law of the place where the object is located. 2. The lex domicilii principle, which means that individual rights and obligations must be regulated by law from the place where a person lives permanently. 3. The principle of lex loci contractus, which means that the agreements, involving the parties of citizens from different provinces, apply the law of the place of agreement. B. Second stage, period of personal growth of international civil law 6th to 10th century. At this time the Roman Empire was conquered by barbarians and the territory of the former Roman colonies, and consequently ius civil during the Roman Empire was useless. At this time several genealogical principles were developed, namely, 1. General principle stipulates that in every legal dispute resolution process, the law used is the law of the defendant. 2. Determination of the ability to make an agreement for someone must be done based on the personal law of each party. 3. The process of inheritance must be carried out based on personal law of the testator. 4. Transfer of ownership of objects must be carried out in accordance with the personal law of the transferor. 5. Settlement of cases regarding acts that violate the law must be done based on personal law on the part of the perpetrators of acts that violate the law. 6. Ratification of a marriage must be carried out based on the law of the husband. See third phase, 11-12th century of territorial principles in Italy. The growth of the genealogical principle is difficult to maintain due to the structure of society, which is increasingly leaning towards territorialistic societies throughout Europe. The diversity of the local legal systems of these cities is supported by the high intensity of intercity trade, which often raises issues regarding the recognition of foreign rights in the area of a city. In terms of solving this problem, to answer the dispute can be considered as a trigger for the growth of the theory of international civil law, known as the statute theory, in the 13th century until the 15th century. D. The fourth stage, development of statute theory, which consists of 3 theoretical developments in 3 different countries, namely: 1. Development of statute theory in Italy, ages 13 to 15. Basics of statute theory. The birth of the Italian statute theory was triggered by the idea of a post-glaciator figure named accursius, namely, if a person who comes from a certain city in Italy is sued in another city, then he cannot be prosecuted under the law of another city because he is not the legal subject of the city. 2. Development of statute theory in France, 16th century. The development of the statute theory in France occurred in the 16th century AD. Situation in France, 16th century. The structure of French statehood in this century pushed to study the relationship of disputes intensively. French legal experts try to live and modify the theory of the Italian statute and apply it to conflicts between provinces in France. Method of settlement. The legal experts explore and modify the statute theory and apply it in the Italian province. Some famous statute theorists in France are Dumoulin, 1500 to 1566, and D'Argentré, 1523 to 1603. 3. Development of statute theory in the Netherlands, ages 17 to 18. People in the Netherlands statute theory are Ulrich Huber, 1636 to 1694, and Johannes Fuet, 1647 to 1714. The basic principle used as a starting point in the theory of the Dutch statute is the exclusive sovereignty of the state that applies within the territory of a country. According to Ulrich, to settle international civil law cases, Ulrich believes that people must start from 3 basic principles, namely: 1. The law of a country only applies within the territorial boundaries of that country. 2. All persons or legal subjects are permanently or temporarily within the territorial territory of a sovereign country. 3. Based on the principle of courtesy between nations, the law in force in the country of origin still has power in force everywhere, as long as it does not conflict with the interests of the legal subject of the confirming state. According to Johannes Fuet, he reiterated the teachings of Gentitas community, namely: 1. The application of foreign law in a country is not an international legal obligation. 2. A foreign country cannot demand recognition of its legal rules in the jurisdiction of another country. 3. Therefore, the recognition of the enactment of a foreign law is only done for the sake of social relations between countries. 4. However, the principle of gentium commodity must be obeyed by each country, and this principle must be considered as part of a country's national legal system. The 5th stage, universal international civil law theory, 19th century. The figure who sparked this theory was Friedrich Karl v. Savigny from Germany. Savigny's thoughts also developed after being preceded by the thoughts of another character who also came from Germany, namely C.G. von Wacher, who criticized that the Italian statute theory was considered to cause legal uncertainty. Wacher assumes that the forum's internal law is only made for and only applies to local legal cases. Because of this, the rules of the case for private international law are those that must provide the rules of private international law. Meanwhile, the view of F.C. von Savigny is that, one Savigny tried to use the concept of legal seat assuming that for every type of legal relationship, the legal seat can be determined by looking at the nature of the relationship. 2. If people want to determine what legal rules should apply in a case that arises from a legal relationship. 3. Savigny thinks that the legal seat must be determined in advance, and the way is to localize the legal position of the legal relationship through the help of link points. 4. If the legal domicile of a type of legal relationship has been determined, the legal system of that place will be used as lex causa. 5. After the legal domicile can always be localized, through the application of the same linking points in the same legal relationship. 6. The principle of law is the principle of international civil law, which according to the traditional approach contains a defining link point that must be used in order to determine lex causa. 7. Use a principle of HPI that is permanent to resolve various HPI cases. That's the history of the development of private international law. Now, let's talk about why him sleep? Maybe he is boring about the history or something. But never mind. After I finish this all explanation, I will punish him, ha 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 ha. Okay guys, just forget about him and listen to my explanation. Now we will talk about what is definition of private international law or conflict of law. What is meant by international? International is the relationship or legal event contains foreign elements. So, if for example we have a trade or contract issue which is related to foreign people, it can be said that we are already in the realm of private international law. Regarding the understanding of private international law, there are two types of flow. 1. Internationality. There must be a civil law that applies throughout the world / several countries. 2. Nationality. Each country has its own international civil law. Meaning, each country has its own regulations on civil actions that contain foreign elements. 1. Foreign people, or we have problem with another people from another country about private international law. Example, Buddy is an Indonesian citizen. When he goes to his workplace, suddenly he hits a Singaporean male. As a result of these acts of kindness, the Singaporean citizen reported the matter to the Jakarta District Court. 2. The place of the action or the place where. 2. According to R. H. Graveson, private international law deals with cases in which it contains relevant facts relating to another legal system, either because its territory can raise its own legal issues or foreign law to decide cases or cause problems in the implementation of the jurisdiction of the court itself or foreign. 3. Van Takel. Private international law is national law written or held for international legal relations. 4. Siddhartha Gautama. Private international law is the entire regulation and legal decision that shows which legal system applies or what is the law if the relationships and events between citizens, the state at a certain time shows the point of connection with the legal norms, from two or more different countries in environments, power, private space, questions. 5. Masmuim. Private international law is the entire legal provisions that determine the civil law of the country in which a case that has roots in more than one country must be. Thus, in general, the understanding of private international law is the whole legal methods and principles governing civil relations that cross national borders or laws governing civil law relations between legal actors, each subject to different, national, civil law. Now we know what private international law is. Now let us discuss the elements of private international law. There have 4 elements in private international law, namely, 1. Foreign people, or we have problem with another people from another country about private international law. Example, Buddy is an Indonesian citizen. When he goes to his workplace, suddenly he hits a Singaporean male. As a result of these acts of kindness, the Singaporean citizen reported the matter to the Jakarta District Court. 2. The place of the action or the place where make problem with another people from another country. Example, On Sunday, Iwan and his friends went to Brunei to travel. When they arrived in Brunei, they rented a car for them to use traveling. When Iwan wants to travel, Iwan accidentally bumps into a pedestrian who wants to cross the road. The person who was hit was a Thai citizen. The woman immediately reported Iwan to the Brunei District Court. 3. The place of the items or where the disputed object is located. Example: Charles is a Dutch citizen. He is married to Claudia, a French woman. Charles has luxury home assets in Singapore. When he died, Charles made a will containing his assets in Singapore to his wife. However, when Claudia went to Singapore to claim the will, there was another woman who was a Singaporean who recognized that the house was his property, and she provided proof of the letter to Claudia. For not accepting this, Claudia immediately sued the woman in the Singapore court because of the disputed assets in Singapore. 4. The place of conduct or a place where a law can apply and solve a problem. Example: Hendrik is an Italian male married to Harika, who is a Japanese woman. They both got married in Bali, and they got married using the basis of Indonesian law and Indonesian tradition. After we know about what is elements in private international law, I will continue to explain about the scope of private international law. There are 4 types of scopes of private international law, namely: 1. The most narrow streams embraced by Germany and the Netherlands, that includes Tekstupassengracht, the law in effect to solve problems that contain foreign elements. Thus this narrow stream is talking about choice of law. 2. Saying that the broad field of private international law, regarding which judges must solve the problem that contains foreign elements. After that, then the legal dispute is applied to the problem. Therefore this understanding or school contains choice of law and choice of jurisdiction. This second understanding is shared by Anglo-Saxon countries. 3. The area of private international law includes, which judge must resolve the problem, what laws are used, and the status or position of the foreigner. This flow is adopted by Italy and Spain. 4. The area of private international law includes, which judge must resolve the problem, what laws are used, the status/position of the foreigner, and citizenship. This flow is adopted by the French. When viewed from the scope of the private international law, the main problems faced by private international law are: first, regarding the choice of law to solve problems that contain foreign elements. While the second problem, regarding choice of jurisdiction to solve problems that contain foreign elements. Third, the extent to which a judge's decision from a country is recognized regarding the rights and obligations arising from the decision. So, if we shorten the language of the scope of private international above, then the scope of private international law is divided into 4, namely: 1. Choice of law. Choice of law is the law in effect to solve problems that contain foreign elements. 2. Choice of jurisdiction. Choice of jurisdiction is judges must solve the problem that contains foreign elements. After that, then the legal dispute is applied to the problem. 3. Judges must solve the problem, what laws are used, and the status or position of the foreigner. 4. Judges must solve the problem, what laws are used, the status or position of the foreigner, and citizenship. Okay, now we know about what is the scope of private international law. Next we will talk about what is resources of private international law. Before we enter the private international law source, let's look at his condition. He's still sleeping. Okay, maybe in a few moments he will wake up, or maybe never will wake up again. We don't know about that, and it doesn't matter to me if he doesn't wake up again. Ha 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 ha. Let's focus the next topic. Sources from private international law are divided into 2, namely: 1. Written, which is written, is divided into 2 again, namely, law and treaties. 2. Unwritten, which is not written, also divided into 2, namely, jurisprudence and wisdom. More information. 1. Law is a collection of rules made by the government which are coercive and binding for all parties where, if they violate these rules, they will be sanctioned. 2. A treaty is an agreement or cooperation carried out by 2 or more countries. 3. Jurisprudence is the decision of a previous judge in a case that is not regulated by law and then used as a basis by other judges for the same case. 4. Wisdom is a decision made systematically by the government with specific aims and objectives concerning the public interest. That's all about sources of private international law. Now I will explain to you about the last part of private international law. That is principles of private international law. The principle of private international law is divided into 9, that is. 1. The principle of lex loci celebration is a principle which states that the place of marriage is inaugurated or held, then using the legal system where the place of marriage was formalized. 2. Domicile principle is the principle that determines where the legal subject is domiciled or residing legally according to law. 3. The principle of nationality, namely the principle of nationality of a person. 4. Lex fori or lawsuit. If the object of the lawsuit is in motion, then file a lawsuit based on where the moving difference is located. 5. Lex site is if the object of a lawsuit is immovable, then in the case of a claim where the object is located. 6. Lex loci contractus is the principle regarding where a contractual agreement is made and agreed by the parties. 7. Lex loci solutionis is the principle on which the agreement is made and the parties are free in terms of determining the choice of law in the event of default or sanctita that will occur behind the day. 8. The freedom of contract is the principle of freedom of contract, which means that everyone can determine the contents and form of the agreement, while the contents of the agreement do not conflict with the law, the agreement is valid. 9. Lex causi is the determination of how a legal act is limited by the legal system that will be enforced. Okay guys, that is all about private international law. Now we will talk about the cases of private international law.
Wait, Cortana, you don't explain to them about applicative private international law in monism and dualism countries.
Wow. You still live, I think you died.
Wait, I just sleep, not die.
Thank you for reminding me, sleepyhead.
No problem. And I'm not sleepyhead.
Sorry guys, I forget to explain to you about how private international law is applied in a monism country and a dualism country. Okay, now I will explain to you about application private international law in monism country and dualism country. Actually, the application of private international law in monism country is very simple compared to dualism country. That is because monism countries are countries where they unite the national law in their country with international law. So, in other words, private international law can be directly applied in monism countries without having to be ratified first. Examples of monism countries: Netherlands, Germany, France. Whereas the application of private international law in dualism countries is very difficult because it needs to be tested and ratified beforehand in dualism countries. Examples of dualism countries: US, UK and Australia. I don't miss something again, right?
Yes, Cortana, you don't make mistake again. And now you must explain about the case of private international law in real case and unreal case.
Wait, why you order me to explain the cases of private international law?
Because I pay you money.
Okay, no problem to me, because he pay money to me. So guys, I will explain to you and resolved a few cases about private international law. The first case I will show you the real regarding divorce between African nationals settled in Indonesian courts. This lawsuit was filed by a husband who called himself Thomas, who is a South African citizen, holder of passport No. M00096351 and Kitas, limited stay permit card, in Indonesia, issued by the Ngurah Immigration Office, currently based in Badung, Bali. That Thomas and his wife had been married since December 12, 1975 and were explained in the complete marriage certificate issued by the Ministry of Internal Affairs of the Republic of South Africa No. Q10424 on December 12, 2005. That since the marriage took place until now they have not been blessed with a child. It's been 10 years since Thomas and his wife have not lived in one house. Both husband and wife work together in the hotel business, but they work in a different hotel, so they have to travel abroad individually, which results in them rarely seeing each other. Because they had separated for 10 years in the sense that they did not live in one house, then Thomas filed for divorce to the Denpasar District Court where he and his wife were domiciled now, and his wife also agreed to it. How to resolve the case above? In the above case we can find out the elements of private international law, namely, 1. Nationality, because Thomas and his wife, they are a married couple who are citizens of South Africa, or lex patri, Thomas and his wife is a South African. 2. Lex domicile, Thomas and his wife's permanent residence is in Bali. 3. The place where the divorce lawsuit filed by Thomas against his wife was filed in the Denpasar District Court. 4. Lex fore, if the husband does not currently have a place of residence or actual residence in Indonesia, the claim must be forwarded to the district court where the actual residence of the wife is. 5. Lex causa, of the case according to Article 18 of which contains the form of each act is determined according to the law of the country or place where the act was committed. Locus regit actum. From the sound of the article, which is the source of international civil law, the lex causa of this case is Indonesian law. The conclusion is that in resolving divorce cases submitted by foreign nationals in Indonesian courts can be resolved in Indonesia, provided that the judicial process is in accordance with formal law and statutory regulations in Indonesia. In addition, the Denpasar District Court has the authority to examine and try in a foreign citizen's divorce case based on the place of residence of the defendant, forum rei, namely in Indonesia, and the consideration of the Supreme Court, which grants the South African citizenship divorce suit in accordance with the principles of civil law international. The material law used is Indonesian law as the basis for examining a claim filed by the plaintiff. The second still real case, this case about IKEA trademark patent dispute. The chronology, the dispute. There was a dispute over rights between IKEA, in which a well-known company which is domiciled in the Netherlands is suing the local IKEA, namely IKEA Company. This case began in 2013 ago. PT Ratania Khatulistiwa sued IKEA and the Director General of Intellectual Property Rights, IPR, at the Central Jakarta Commercial Court related to the cancellation of the IKEA brand for goods classes 20 and 21. Ratania is known to have registered the name IKEA, which stands for Intan Khatulistiwa Esa Abadi, IKEA, in December 2013. Meanwhile, IKEA, Netherlands, stands for the name and origin of its founder, Ingvar Kamprad, and the Elmterid farm and village Agunnerid. After that, the IKEA Dutch directly IKEA owned by Ratania Company to the Central Jakarta District Court. The final short story of this case is that the Supreme Court rejected this case on the grounds that the mark, which was not used by the owner for 3 consecutive years, could be removed from the General Register of Marks. Because of that reason, the Supreme Court ruled against the case. The elements of private international law in the case is: 1. Lex locatus, or law from the place where the act is carried out, is Indonesia. 2. Lex areicity, or the law of the place where the object remains, is Indonesia. 3. The lex cause, or legal system used to resolve private international law cases, is Indonesia. 4. Lex fore, or the legal system of the place where the legal problem is filed, is Indonesia. 5. Lex domicili IKEA is Netherlands, while Ratania is from Indonesia. 6. Loci actus in Indonesia. The reason why the above case can be decided in Indonesia. That is because from the elements of private international law contained in the cases above more dominated by Indonesia, so that Indonesia can be used as a forum to resolve the above case and can also use the Indonesian legal basis. The private international law element contained in the IKEA case above is. The third case we will talk about, case Adidas AG versus Adidas Local. Chronology of case. This case began when Adidas AG judged Jimmy Sanjaya imitating his logo on the Sportman brand. While Jimmy claimed to have registered his 3-strip mark with the Directorate General of Intellectual Property, DITJANKI, with no IDM 0002100005 and no IDM 00015333SD with item class, NICE, number 25. International Adidas assesses that the logo used by Jimmy in the Sportman brand has a striking resemblance to his own. This can be seen from the 3-bar logo that has similarities in principle or in its entirety. While Adidas version of Jimmy has a proportion of 3 beams with gradual height difference. Adidas AG claims the logo resembles his famous 3 bars and 3 stripes. For this, Adidas AG then filed a lawsuit with the Commercial Court at the Central Jakarta District Court. In this case, the company Adidas AG actually withdrew this case so that this case ended with the decision to revoke the case from the Supreme Court. Private International Law Element 1. Lex Locietas or law from the place where the act is carried out is Indonesia. 2. Lex Rei seizure or the law of the place where the object remains is Indonesia. 3. The lex cause or legal system is used to resolve private international law cases is Indonesia. 4. Lex fore or the legal system of the place where the legal problem is filed is Indonesia. 5. Lex domicili Adidas is US while Jimmy is from Indonesia. The reason why this decision can be decided in Indonesia itself is because most of the international private elements in the case are Indonesia. So Indonesia can participate in deciding the case above. The 4th I will talk about Unreal case. The cases happen between IPB dan America. The chronology of the case. Case of IPB and America. IPB entered into an agreement in Indonesia to send 800 monkeys to America. The monkeys would only be taken by their children and the baboons would be returned to Indonesia. The price of the chopper was agreed at 80 million and the United States only needed its children and had to have children in the United States. When the plane's position was still in Switzerland, a monkey was stressed and released, giving birth to his child. Because the mother had been paralyzed and died, the veterinarian of IPB injected the monkey to death because of pity. Lawyer of the United States is demanding IPB on the basis of animal protection and is deemed not to fulfill his achievements perfectly and to kill a monkey child. On one hand, monkeys in Indonesia are no more pests, whereas for the United States they are animals that must be protected. The facts: 1. IPB entered into an agreement in Indonesia with the United States to send 800 monkeys to the United States. The monkeys would only be taken by their children and the price of the tail was 80 million. 2. America only needs its children and must have children in the United States. 3. When the aircraft's position is in Switzerland, a monkey is stressed and released, gives birth to his child, and his mother has been paralyzed and died. 4. Veterinarian of IPB injects dead monkey child out of pity. 5. Lawyer America demanded IPB on the basis of animal protection and was deemed to have not fulfilled the achievements, and killed a young monkey. 6. Monkey child for America is a protected animal. Private international elements contained in the case above. 1. Lex patri lawyer is an American citizen while the veterinarian is Indonesian. 2. Lex loci contractus, the law where the agreement was held, namely Indonesia. 3. Lex loci solutionis, the law where the agreement was implemented, namely the United States. 4. Lex loci delicti commission, the law where the act against the law is carried out, is Swiss. 5. The most characteristic connection, the more prominent party in the contract, is Indonesia. In that case, we can say based on the elements of private international law above, the forum that can adjudicate the above case can be held in the Indonesian forum and the legal basis that can be used is the legal basis of the Swiss due to legal actions at the Swiss border. The final case I will give one example of another case, the Babcock and Jackson case. Case chronology. Miss Georgia Babcock is a German citizen with friends. Mr. and Mrs. William Jackson went for a weekend to Canada on September 16, 1960, in a Jackson car. They are all residents of Rochester, New York. Time passes through the province of Ontario. They had an accident that caused Miss Babcock to be seriously injured. Upon returning to New York, Miss Babcock made compensation claims against Jackson based on negligence. At the time of the accident, in Ontario a guest statute applies, which in essence determines that people who are only free guests cannot claim any compensation in the event of an accident. Such provisions do not exist in the laws of the state of New York. The facts: 1. Miss Georgia Babcock with her friends, Mr. and Mrs. William Jackson went for a weekend to Canada on September 16, 1960, in a Jackson car. They are all residents of Rochester, New York. 2. Time passes through the province of Ontario. They had an accident that caused Miss Babcock to be seriously injured. 3. Upon returning to New York, Miss Babcock made a claim for compensation on Jackson based on negligence. 4. When an accident occurs, in Ontario a guest statute applies, which in essence determines that people who are only guests without payment cannot claim any compensation in the event of an accident. Private international law element contained in the case above is 1. Lex locus delicti commissi, which is Ontario law as the law of the accident. 2. Lex Patrii. Miss Babcock and Mr. and Mrs. William Jackson is New York. Factors that state this are: 1. The lawsuit was filed by a New York guest against the New York host. 2. Driver's license and car insurance in New York. 3. This weekend journey begins and is expected to end in New York. In the above case we can say that the competent forum to resolve the above case is the law in New York, and the legal basis that can be used in resolving the case above is the legal basis in New York. Due to the above factors that support that it must be applied using a legal basis and a forum from New York. That is all I can explain to you about definition of private international law or conflict of law. I hope you enjoy my explanation, and I want to say sorry to you if I have bad word in my explanation, and also I want to say sorry if my word make you hurt. Last word, I want to say see ya.
Okay, Cortana, thank you about your explanation.
You are welcome.
Okay guys, until here just an explanation that can be conveyed by Cortana. And the same, I also want to apologize if my friend Cortana used the wrong words that make all of you feel offended. And until this is our video, and Cortana, I will have something else to want to say.
Yeah, don't forget to pay me, because I tired to explain the topic.
Why she remembered about the payment. But no problem, after this video I will pay her because her do the great job, so maybe I pay her. Okay, no problem. Okay guys, after here our video, and last thing I want to say, see ya.